Okay, good evening. Am I audible and visible to everyone?
Good evening, sir. Yes, sir.
Yes, sir.
Yes, I can receive your voice.
Okay, sir, it is clear.
Right.
Yes, it's clear.
Right.
now.
Good evening and welcome all of you. On behalf of National Institute of Labour Studies of Sri Lanka, I warmly welcome all of you for the introductory seminar of and to select NILS as your learning partner. I would say like NILS, we have about short history, about 10 to 12 years history that we started in 2010. And this is a government organization. This is under Ministry of Labour, Sri Lanka. Can you hear me properly?
Sometimes it's getting.
Just
Sometimes
lagging.
it is getting trouble. Sometimes it is getting trouble.
Okay. How is now?
Now it's
Am I
okay.
audible now?
Yeah.
Yes, sir. Okay. Now it's
Now
okay.
it's okay.
Okay.
Right. Thank you. Thank you. What I was talking to you about NILS. So this is under Ministry of Labour, and our headquarters is in Narahempita in the Labour Department of Sri Lanka. So you have taken a right decision to get your knowledge partner. NILS is one of the most respected institute in Sri Lanka. So we have such a wonderful lecture panel today, and then this diploma program that will run for 12 months, and then you will get all what you need to know about industrial relations and labor law in Sri Lanka. So for the introductory speech, I would like to invite Mr. Suranga Gunaratna. Mr. Suranga Gunaratna, he is a Director General of National Institute of Labour Studies of Sri Lanka. I think you can hear me, sir. And Mr. Suranga, he's a senior officer in Sri Lanka Administrative Service with 20 years of experience, and he has a Masters of Business Administration degree from University of Gloucestershire, and then master degree in project management from John Moores University in Liverpool, and then he is a graduate of University of Caledonia, and then he is a certified Lean Six Sigma black belt holder. So we are proud to call you as Director General, sir. Warmly invite you to deliver the introductory speech with the welcome note to all the lecture panels. Over to you, sir.
Thank you, Mr. Sankar. I think I am audible to all of you. Is it okay, Mr. Sankar?
Yes, we can hear
Yes, sir. Yes, sir.
Okay, thank you.
Yeah, audible.
Professor Sarveswaran, Mr. Kumara, Wickramarachchi, and our participant and our interested parties for this introductory seminar. On behalf of National Institute of Labour Studies, we warmly welcome all of you. Thank you, Mr. Sankar, for introducing me. And on behalf of National Institute of Labour Studies, NILS, so I would like to explain the program content and curricula in brief. So, because today we have 2 guest lectures. Here is our vision and mission Our vision is industrial peace and harmony for socio-economic development of Sri Lanka. As mentioned in our mission statement, we have to facilitate tri-party constitution. Tri-party means public sector, private sector employees, and private sector employers. So we have to get the balance between these two parties to maintain, to develop and maintain a productive labor relation to education, research, and training. So our main, as an IELTS, we are functioning under the Ministry of Labor. So as a training organization, we are targeting education, research, and learning to develop career professional on labor relations and HRA. We were established in 2007 to providing education, training, consultancy, and advisory services. Our main aim is facilitating workplace harmony by developing professionals in these areas like labor relations, labor law, HRM, and other labor studies areas. We were fortunate to legally incorporated by the Parliament of Democratic Socialist Republic of Sri Lanka by the National Institute of Labour Studies Act number 12 of 2010. As an organization, we have more than nearly 20 years experience in this area. You can see our diplomas and certificate courses. The main diploma we are conducting is industrial relation and labor law and application. As a organization, we are supposed to develop industrial relations. So we are conducting this valuable diploma on industrial relation and labor law application. In addition to that, we are conducting human resource management diploma and certificate course, business management, and office management courses. These are all the courses. Can't you hear properly?
Can hear, sir.
Okay.
Yes, we can hear.
Okay, thank you. All the courses are 1 year diploma, and in the certificate courses, it goes around 3 to 4 months. As a national organization, we are offering national diplomas and national certificate courses. So when I come to the subject, in the first time in Sri Lanka, we can offer NVQ level 5 for this diploma under the guidance of TVC, Treasury and Vocational Education Commission. They have published these standards. We are offering this course according to their standards. So align with their standards. Then we can give the NVQ 5 level certificate amalgamated with national diploma certificate. So our English medium batch will start next week, and parallelly we will start Sinhala and Tamil medium courses May 2023. But I want to tell something. This year we got a special approval to offer NVQ 5 level standards for all the 3 languages program. I mean, Sinhala medium program, Tamil medium program, and English medium program. We can offer NVQ level 5. Basically, it was only for English medium. Now we have special approval to offer NVQ level 5 for 5 certification diploma for any languages. That's a valuable point I want to mention. I will explain this course module later. It consists 14 modules, including project-based assignments. one action learning module. All together 14 modules. We follow, as a national organization, we have to follow this national competency standard set by the TBC. They have set this national competency standard for industrial relation and labor law application NVQ 5 level diploma. You can download this document from their website, or we can share this document to your WhatsApp group and email addresses. These are the core technical competencies cover this diploma. You can see there are 10 technical competencies we have to address. After the completing this training program, you have to acquire this knowledge, skills, and attitude. So these are the set of skills after completing this training program. I will go to the modules. There are 11 technical modules in this diploma. First one is Introduction to Labor Relation. Second, Workforce Development for Industrial Harmony. Planning industrial relation activities. Then you can see that what is how these modules are set, because these modules were set by the panel of experts from the private sector, public sector, and academia. I think Prof. Sarveswaran also participate. They developed this module parallel with the other countries' experience and our country's requirement. Occupational safety, health, and health with related labor laws. Number 6, labor laws in industrial relations, very relevant to social security. Number 7, bargaining process for industrial harmony, employee disciplinary functions, coordination with government entities and other institutions. Number 10 module, legal forums and practices related to labor laws. Number 11, project-based assignment is a kind of action learning project. In addition to these technical modules, you have to complete employability modules with level 5. In any courses, we have to follow these employability modules in the level 5. Workplace information management, workplace communication management, planning and scheduling work at workplace. I will show some how to cover the standard time, standard scheduling of this training program. It's this training program, according to the criteria, we have to cover 1,500 notional hours. 1,500 notional hours. Notional hours means it includes lectures, tutorials, practical and industry visit, and self-studies. As you can see, module number 1, Introduction to Industrial Relations. Notional hours, 50 notional hours. For lectures, we will conduct 20 hours. Practical and industry visit. Practical means assignments also we can consider as a practicals. And industry visit 10 hours. Self-study for you to do 20 hours. Our main objective is covering lectures and tutorial and practical and industry visit. So in addition to that, when you are doing your assignments and when you are doing your action learning project, you can complete the self-study hours. We have to maintain a record book according to the NVQ criteria. So we will do everything. For semester 1, you have this module, 5 technical modules, and you can start the action learning project. In addition to that, 1 employability module. For semester 2, you can cover other modules. by continuing also action learning project and 2 employability modules, workplace communication management and planning and scheduling work at workplace. These are the curriculum of this training program, this diploma. And as I said earlier, we will start this program from this Saturday. It's a physical class, but some participants requested us to have an online session. So we will deliver the physical class mode as online. It's like a hybrid module. But for the exam, you have to come to our office because this consists summative assessment. It means end of each semester you have an exams. Only 2 semesters you have to cover. Then 2 exams we are supposed to conduct. Some participant asked, can we join with the online mode? Says we have online mode, but we are delivering our physical classes to webcam. That's the way we are doing, because 100% we can't go to the online mode because we have examination have to conduct in the physical mode and some kind of practical role plays. We are flexible. We can make some adjustment under the guidance of TVC. So at finally, my team, my assistant director, Mr. Priyanta, and program officer, Ms. Purnima, and they are handling this program. And based on previous year's experience, we have master's degree holders, diploma degree holders, and private sector and public sector employees. They have completed this diploma because as in the HR profession, they need this qualification to run their business and to career advancement of their to career advancement. In addition to that, from next year, we are going to develop in this NVQ level 6 criteria, advanced national diploma in industrial relation and labor law application to fulfill another gap. So thank you very much.
I have a question. Can I ask?
Yeah.
So I'm currently looking for job in Gulf countries.
Yeah.
So I'm not sure when will I get the job, but I'm more interested to follow this program.
Yeah.
You told that you have 2 semesters.
Yeah.
Can you tell me, sir, when will be the exam that semester will be there?
Yeah. I will check with our program schedule, and we will let you know the exam schedule exactly. Sometimes if we start the March program, it take 5 months to complete the all the modules. Then March mean somewhere in September, we will conduct the first semester exam, and next year, March, February, we will conduct the second semester examination.
For the first semester, I will be able to participate.
Yeah.
For the second semester, I won't be in Sri Lanka. So will I able to take this exam to next page?
We will check with the TVC if there are any possibility to conduct the exam in the online mode. If then you can pace the same year. If they are unable to give the approval to us, then you can complete with the next batch.
Excuse me, sir. I
Yeah.
also have that problem because I'm traveling on April to Canada. So if it is possible to sit exam on online, it is, I think it's that is good for me.
Yeah, okay. We will check with TVC. They are the regulating body, and let you know.
Okay, sir. Thank you.
Okay, thank you for your question. I will be there in the last session. We can have a more Q&A session. Last part of this session, we can have a Q&A session. So I would like to invite our guest speakers. I am so proud and so happy to invite Professor A. Sarveswaran and Mr. Kumara Hettiarachchi, because they are key resource person of this diploma and other labor relation programs in the NICE. I think they have joined with NICE as an external resource person more than 15 years. So it's give me a great pleasure to introduce Professor A. Sarveswaran. I think most of you know him, and Mr. Kumara Hettiarachchi, Wickramarachchi. Professor Sarveswaran is an attorney at law, and he completed a LLB degree from University of Colombo, and he completed his master's from University of Peace from in Costa Rica, and MP from University of Colombo. And he's a very renowned resource person on labor law and industrial relation. I kindly invite you to start the guest lecture today, importance of labor law. So, dear sir, this is your time to start the program.
Thank you, sir. Good evening, everyone.
Good evening, sir.
I think you all can see me. I'm audible
Yes,
also, right?
Yes, sir.
Yes.
Okay. So, Mr. Suranga Gunaratna, the Director General, Assistant Director, Mr. Priyanda Kumara, my colleague, Mr. Kumara Wickramarachchi, Mr. Lalit Kumara Wickramarachchi, Mr. Sangha, and also Ms. Purnima and the participants. So when it comes to this program, I have been asked to speak mainly on the topic of importance of labor law. So when it comes to this program, importance of labor law, I would like to touch on the important aspects, because I don't think I will be able to cover the India thing today, right? But anyway, our DG has clearly explained about the modules that we are having in our diploma program, the National Diploma in Industrial Relations and Labor Law Applications. So there, as our DGs explained, there are many modules. When it comes to these modules, again, there are many branches in the modules. So for an example, if we take health and safety, there are many branches coming under the particular module. And also when it comes to the labor law part, there are many labor statutes also. So in that way, when it comes to this program, it will have many modules, and also the modules will have many sub branches, and also many labor statutes or the labor legislation enacted by Parliament. Also the regulations gazetted under the important labor legislation will be covered. So by the time you finish this course, you will have a very good understanding, knowledge, and the skills and all with regard to all these important labor laws, and also the practices of industrial relations, to some extent the theories in industrial relations and labor law part. So when it comes to me, my topic is about the importance of labor law, right? Importance of labor law. When it comes to importance of labor law, Here I am going to explain briefly about the importance of labor law and also the important sources of labor law in Sri Lanka and the important areas in labor law, right? So these are the things that I'm going to share with you, right? Maybe I may take about 1 hour, and thereafter, maybe if you have any doubt, you can of course ask me the questions and all. So then when it comes to the importance of labor law, right? It is important, I would say, when it comes to those who are in the field of human resource management. When it comes to labor law, it deals with the labor matters that arise in employer-employee relationship. When it comes to a human resource manager, the manager should have a better understanding of labor law, because the manager should know what to do, what not to do. Sometimes by my experience, I know sometimes when some matters come for discussion or consultation, I find that already the person is dead. The patient has died. Now the doctor can't do anything with the patient because already the patient has died. So it is too late. Why? Because the manager or the employer, right? The manager or the employer has killed the patient. They kill the case. Thereafter, we can't do anything. It is too late. So therefore, you have to have a very good understanding of labor laws, not to make the mistakes, not to do what we can't rectify later, at the same time, to comply with the labor standards, to comply with the labor statutes, and also to protect the rights of the workers, also to maintain industrial peace in the country, right? Therefore, labor law becomes an important subject when it comes to those who are in the field of human resource management. But there could be many people who are not really the human resource managers. Then when it comes to those people, you may ask me whether labor law is important. I would say yes. Why? Because I will give an example. Now we will take a construction company. So when it comes to the construction company, right, the chief person or the chief executive officer may be an engineer, but there are many workers working under him. So when it comes to the workers who work under him, he manages the workers, and when there is any relationship, the conflicts are inevitable, and the rights and duties and all will arise. The person who is managing them, even though he is an engineer, he should have a good understanding of labor law. Likewise, not only the managers, right, even the others. A doctor, the doctor is in charge to the hospital. So there are many people working in the hospital. So the doctor should know what is in labor law. Likewise, labor law becomes an important subject to everyone. Also, if you are a manager, you should know the labor law. If you are an employee also, you should know labor law. Without having a good understanding in labor law, you can't be a successful manager. So labor law becomes an important part of human resource management. But as I explained earlier, it becomes important not only for the human resource managers, even for the other people who manage the organization, manage the workers, and deal with the labor issues. Then when it comes to the sources of labor law of Sri Lanka, I would say mainly when it comes to the sources of labor law, we have many labor statutes enacted by our parliament, the legislature. Can you give me some examples for the labor statutes we have, the labor legislation we have in Sri Lanka? What are the some examples about
Industrial Dispute Act.
Very good. The Industrial Disputes Act, which
Then
provides
Teva.
the
Then you get Teva.
very good. Teva, very good. Right? The Industrial Disputes Act, which provides the mechanisms for settlement of industrial disputes. So when it comes to industrial disputes, it is always better to settle the disputes within the workplace. So that part we cover under industrial relations. But if we can't settle the disputes within the organization, within the workplace, then we have to come under the law. And the Industrial Disputes Act provides the mechanisms for settlement of industrial disputes. Then you mentioned about Teva. Teva, in short form, we say Teva. It is termination of employment of workmen Special Provisions Act. So the Teva mainly deals with non-disciplinary terminations in the private sector, where 15 or more workers are employed. But Teva applies to all the workplaces in the private sector where 15 or more workers are employed, and a worker who has worked more than 180 days comes under the Teva, and the procedure for the termination and all are in the Termination Act. But Teva may not apply within the Colombo Port City area because it could be exempted. Okay, anyway, we will discuss those things later, because when Colombo Port City comes into full operation, again, there will be a big demand for labor laws, because according to the Colombo Port City, that Economic Commission Act, there are about 11 or 12 statutes may not apply within the Colombo Port City area. But when it comes to the labor laws, only the Termination Act will not apply within the Colombo Port City area. So other labor laws will apply, right? We will discuss those things later. What are the other laws you know? Teva, Industrial Disputes Act.
Wages Board Ordinance.
Wages Board Ordinance.
Maternity ordinance.
Maternity Benefits Ordinance.
Budgetary Allowance Band.
Budgetary Relief Allowance Act. Very good.
Minimum wages
Chopin
of
Office
employees.
Act.
National Minimum Wages of Workers Act.
Chopin Office Act.
Chopin Office Employees Act.
Gratuity Act.
Payment of Gratuity Act.
Employee Provident Fund.
EPF.
Employees Provident Fund Act.
Employee Trust Fund.
Sorry,
ETF.
Employee Trust Fund.
ETF, right? Employees Trust Fund Act. Any other labor law?
Private Trainees.
Sorry,
Trainees.
Trainees Act, yes. Any other act?
Indian Burgers.
Sorry,
Indian Burgers.
Indian Labor Ordinance, yes.
Computer crime.
Minimum wage.
Computer Crimes Act. Right, misconduct at workplaces relating to computer crimes.
Minimum wage.
Sorry,
Factory Ordinance.
Factories Ordinance.
Health and safety.
Compensation Act.
Workman Compensation Ordinance.
Minimum wages.
Minimum Wages, National Minimum Wages of Workers Act. Right, yes.
Gratuity.
Payment of Gratuity Act. Employment of Women, Young Person and Children Act.
Chopin Office Act.
Yeah, Chopin Office Employees Act. And also, still, I think you all have not mentioned one of the very recent labor legislation. What is that?
Probation periods.
Sorry?
Regarding the probation period.
Minimum ages. Retirement.
Okay, right, very good. So the minimum retirement age of Workers Act. Minimum retirement age of Workers Act. So it was passed in November 2021, right? I have written one article because I have written articles in almost all the areas, most of the areas. My recent article was on the minimum retirement age of Workers Act, right? My recent article, it has been published. Later you may get a copy of the article also, right? When it comes to that article, actually, when it comes to National Minimum Retirement Age of Workers Act, it is another controversial legislation we have, because many people think the act deals with the minimum retirement age, which is 60. But it goes beyond that. It goes beyond that. I don't know how many of you are familiar with the act, right? But it says, it provides interpretations to the different types of employments. For an example, right, when it comes to the minimum retirement age of Workers Act, it applies to the employees in the private sector where 15 or more workers are employed. Then it says the minimum retirement age is 60. Then it says this act does not apply to certain categories of workers who come under Schedule 2. When it comes to the Schedule 2, there it says probationers, the workers in probationary employment, casual employment, government sector employment, fixed term employment, seasonal employment, all are there. But later we will discuss all these things in detail. But I will just take one example here. Because many managers, many human resource managers, many people who are with the human resource management think this act is only about the minimum retirement age. No, I said it goes beyond that. For an example, I said the minimum retirement age is 60, right? So then it says to certain categories of employees, the act does not apply. For an example, it does not apply to the workers who are in probationary employment. Then Section 18 of the Act provides an interpretation to probationary employment. Anyone has any idea about the interpretation given in the Act for probationary employment? Anyone has any? Sorry?
It has given 180 days to complete the probation period. If the performance is not up to the level, the management can decide and we can extend to another 180 days. Less than.
Very good, excellent. How do you know that?
We studied. I was attended to one of your lectures. That's the
All right, very good. Thank you. You are right. Because the Section 18 of the Act provides an interpretation to probationary employment. It says probationary employment means employment of a worker for a period not exceeding 180 days. Then it says, if the employer is not satisfied with the performance of the probationer, the employer can extend the probationary period for a further period not exceeding 180 days. Altogether, 360 days, the maximum. So here there are two issues. Even recently, I saw one letter of appointment given very recently. There I said, you can't, there they have given the letter of appointment saying probationary employment is 1 year. But I said, according to this act, you can't give a probationary period for 1 year at a stretch, because it says 180 days, but thereafter it could be extended for a period not exceeding 180 days. Now the problem here is, suppose if the organization of the employer covered by this act employs a person as a probationer beyond this period, right? Beyond this period, then what will happen? I think the question is clear to you, because here what I want to tell you is, but I don't want to cover everything today. I don't want to cover everything about the minimum retirement age of workers act today, but just I want to give an idea about the issues that we have when it comes to labor laws, right? The organization, right, has employed a person as a probationer covered by this act for a period more than 360 days. Then what will happen? Because it clearly says probationary period is 180 days, but it could be extended for a further period not exceeding 180 days. Now the organization or the manager doesn't know about this provision, but the manager has employed the probationer covered by this act more than that period. What will happen? Anyone?
So if he is extended without termination, then he becomes a permanent employee.
Permanent employee. Then the worker can work until the age of retirement. That is 60. The employer can't go for premature termination. Then it is violation of the act. And also the person can complain to the commissioner. Commissioner can order reinstatement or sometimes some cases compensation. Right? Otherwise, the employee will have to go to the commissioner under the Termination Act and follow the procedure and get either the consent of the workman or the approval of the commissioner. So it's a very complicated system. What I want to say here is many people think this act is only about the minimum retirement age. Now it has become 60. No, it goes beyond that. Just I have given just one example to make you to understand the issues that we have. Right? There is one question, sir, if it is those kind of employee are not under, sir, if it is those kind of employees are not under TEVA. I don't understand what you ask, right? When it comes to TEVA, that is Termination of Employment of Workmen Special Provisions Act, right? It applies. Actually, the question is, I think now you are right? It is clear to you, right? The Termination Act also applies to the employees in the private sector. There are three conditions to apply the Termination Act. One is private sector. Other one is 15 or more workers at a workplace. The other one is the worker has completed 180 days. Then you have to follow the procedure under the Termination Act to terminate the worker for non-disciplinary reason. Okay, right. So now when it comes to labor laws of Sri Lanka, actually I was telling you about the sources. We have so many labor statutes that you all have mentioned. Also, we have many regulations gazetted under this labor legislation. For an example, if we take the EPF Act, there are regulations under the EPF Act. If we take the Shop and Office Employees Act, there are regulations under the Shop and Office Employees Act. Then we have to look at the legislation. Sometimes we have to look at the regulations. In addition to that, there are judicial interpretations. That means there are so many cases. Every month, we get many cases decided by the Court of Appeal and the Supreme Court, right? The superior courts on these matters. For an example, when it comes to gratuity, I think you mentioned about payment of gratuity. Now, say when it comes to gratuity, there was a case, Brown and Company case. The workman worked until the age of retirement. At the time of retirement, the company has paid the gratuity also. He accepted the gratuity. From the very next day onwards, the particular workman was employed under fixed term contracts for another 19 years. So the question was, when it comes to this situation, whether we have to take the total period together for the calculation of gratuity, or there was a break at the time of retirement. That was the issue, right? When it comes to this case, very interesting case, we will study all these things in detail. The Labor Commissioner interpreted the Payment of Gratuity Act and decided you have to take the total period together, because the workman, even after retirement, was continuing the employment, not continuing the fixed term employment has been given after the retirement, but without any break, no break at all. The previous day, the worker has retired. The next day onwards, the very next day onwards, he was employed under fixed term employments. So you had to take the total period together. That was the decision of the commission. Then the Court of Appeal also earlier has given judgments in the same line, that is, you have to take the total period for the calculation of gratuity. But when the matter went to the Supreme Court decided in the other way. No, there was a break at the time of retirement for two reasons. One is the worker has accepted the gratuity at the time of retirement. Other one is a new employment contract has been given after the retirement. Therefore, there is a break. Even though the worker has worked from the very next day onwards, still there is a break. So it has created a legal principle. So what I want to say is, when it comes to labor law, everything is not in the labor legislation. Everything is not in the labor regulations. There are many legal principles that have developed through the cases decided by the courts. For an example, mainly when it comes to matters relating to disciplinary termination, we don't have any law which specifically deals with the misconducts that justify terminations. Then we have to look at the case law. Likewise, there are many principles that have developed through the cases decided by the courts. Even today evening, actually, there was an issue. One person wanted my opinion about, actually here what happened was, the workers in one company have been transferred to another company without their consent. So now after they transferred the workers to another company, this person wanted my opinion whether it is legally correct, right? Workers who worked in one company, but the directors are the same, but two different companies, right? The directors in the two companies are the same, company A, company B, but the directors of company A are the directors of company B, but these are two different companies. But here what happened was, when it comes to company A, they had to reduce the workers. So they thought better not to go for termination under the Termination Act or follow the procedure under the Termination Act. Better we will transfer these workers to company B, because there were vacancies in company B. So they have transferred the workers to company B without their consent. So they asked me whether it is legally correct. I said no, because there are judicial decisions decided by the courts. If you transfer a worker from one company to another company, even though the directors are the same people in the two companies, that is violation of the Termination Act. If you have obtained their consent, then it is different. But you can't transfer without their consent from one place to another place. It is violation of the termination. Then I said there is a case decided by the Court of Appeal. There are basically many, 2 or 3 cases, right, on this point. So when it comes to these legal principles, again, what I say is, we get all these legal principles from the cases decided by the superior courts. So when it comes to sources of labor law of Sri Lanka, labor laws passed by parliament becomes important, labor regulations become important, also the cases become important. In addition to that, we have books and also we have articles. I mentioned recently I have published one article, and also last Saturday I have submitted another article for publication. That is actually a research journal coming under the Ministry of Labor, right? That article is about exploitation of workers in the informal sector employments in Sri Lanka. Legal responses, because when it comes to Sri Lanka, about 60% of the workers work in the informal sector. many of these workers don't know about their rights. Therefore, they are being exploited also. So that article is basically about that. So when it comes to labor law of Sri Lanka, we have labor laws, regulations, cases, articles, and also books. And also, when it comes to labor law, I said it is very important. At the same time, it is a very complicated area of law because of too many laws, too many regulations, too many cases, conflicting judgments, right? Because when it comes to, if you take a workplace, for an example, we will say, I have a tea estate in Hatton. In that, when it comes to the tea estate, the estate is there. There is a factory in the estate. The factory has an office, right? I repeat again, I have a tea estate in Hatton. So the estate is there. And the estate, there is a factory. The factory has an office. So there are minimum 3 categories of workers at one place. One is the workers who work as tea pluckers in the estate. Other one is the workers who work in the factory. Other one is the employees who work in the office of the factory, right? So then different labor laws apply to them. When it comes to the workers in the office of the, or employees who work in the office of the factory, they come under the Shop and Office Employees Act when it comes to their terms and conditions of employment. When it comes to the workers in the factory, they come under the wages codes. Their health and safety matters come under the factory's ordinance. When it comes to tea pluckers, they may come under the wages codes or collective agreements. So you see, there are 3 different categories of workers coming under different laws. For an example, when it comes to maternity leave, if the female worker works as an employee in the office, her maternity leave comes under the Shop and Office Employees Act. If the female worker works in the factory next door, her maternity leave, maternity benefits and all come under the Maternity Benefits Ordinance. Can anyone tell me now how many days maternity leave under the Shop and Office Employees Act?
84 days.
84 days.
For how many children?
Any number of children.
All children.
For any number?
No limits.
Yes,
No, 3
any
number.
number.
Only 3 numbers.
Only 3?
Yes, sir.
No limit, sir.
No
limits.
limit. Recently amended.
Previously.
So when it comes to labor law, that is what actually very good, right? So I explained the complicated nature of labor law in Sri Lanka. Also, we have sent 225 people to parliament, to the legislature. For what? To enact new legislation, also to amend the existing labor legislation. So they will do that. So when it comes to this, the Shop and Office Employees Act, it was amended in June 2018 by the Amendment Act number 14 of 2018, right? Before the amendment, maternity leave, 84 working days were given when it comes to the first 2 babies. We went by confinement, but anyway, first 2 babies. But after the 2018 amendment, right? Now it is 84 working days for any number of babies. But before the 2018 amendment, 84 working days for the badminton team. But now 84 working days, whether it is a badminton team or football team or cricket team, doesn't matter, right? For any number of babies, if the confinement has resulted in live birth. If the confinement has not resulted in live birth, then 42 working days. So the labor laws I mentioned earlier also, they are amended time to time. When it comes to the recent amendments, one is maybe, as you mentioned, the amendments relating to maternity leave, right? To the amendments were introduced to the Shop and Office Employees Act and also to the Maternity Benefits Ordinance. Are there any other amendments recently? Are there any other amendments very recently?
Yes, there were
EPF amendment.
Sorry?
EPF.
EPF, okay.
And in the EPF amendment, the interpretation for the employer, employee, and so much of the change in interpretation.
Yes. Anything else?
so there were some amendments for the factories ordinance as well.
That is mainly right about this, about the child labor and all, right? But now when it comes to child labor also, right? After January 2021, right? But earlier it was minimum age for employment was
14
anyone?
years.
14 years. Very good.
14 years.
14 years.
Now
But in
16 years.
January 2021, many of our labor statutes have been amended. Now it has been increased to 16 years.
16 years.
But that does not mean you can employ a child above 16 years in any type of employment. No. There is a regulation gazetted in November 2021 under section 20 subsection A of the Employment of Women, Young Person and Children Act. According to that particular regulation, you can't employ a child below 18 years in 71 categories of employments.
Dangerous
The
Dangerous
hazardous or dangerous, harmful to the health, safety, and the morals of the child. So when it comes to that particular regulation, the first one is domestic workers. So that means you can't employ a child below 18 years as a domestic worker. Also, I can proudly say that I am the father of that particular regulation, because earlier there was a regulation, but about some years ago, then they wanted to review the regulation and go for the new one. So then I had to undertake that task, which came under the ILO and the Labor Ministry, and I did that, right? Then it was gazetted. Now we have the new regulation, right, under the Employment of Women, Young Person and Children Act. Any amendment to the Workmen's Compensation Ordinance in March 2022?
And the amount is increased. The regulation.
Amount has been increased. Anything else? Anything else?
Amendments in minimum wages, national minimum wages.
Yeah, that is also right. Earlier it was 10,000 per month. It has been increased to 12,500 per month. Earlier it was 400 per day. Now it has been increased to 500. When it comes to the Workman Compensation Ordinance, there was a progressive amendment. That is, earlier when it comes to the liability of an employer to pay compensation, it was saying accidents arising out of and in the course of his employment. Generally, the accident during the working hours while the worker is performing the work for the benefit of the employer during the normal work. That was the situation under which the employer had the liability to pay compensation to a worker for industrial accident. Then in March 2022, this section has been amended. Now it says, if there is an accident, right, on the way from the residence to the workplace, or on the way back from the workplace to the residence also, the employer will have the liability to pay compensation, right? Right, on the way from the residence, from his residence to the workplace, or on the way back from his workplace to the residence. If there is an accident, the employer is liable to pay compensation. So what I want to say here is, the labor laws are always being amended. So new amendments come, right? Then we have to look at the amendments and comply with them. So when it comes to the overview of labor law, mainly it covers the areas like contract of employment. When it comes to contract of employment, we say the letter of appointment, right? Letter of, okay, right? letter of appointment, right? So the other one is, well, that is what we say, contract of employment. Just I want to know whether there is a requirement in Sri Lanka to give a written letter of appointment to create employee-employee relationship or no need? Yes. Under the Shopon Office Employees Act,
Section 8.
Section 17, right?
7, sir.
Yes, Section 17 says a letter of appointment should be given. Now we will say there is a Kothuroti Kada. An employee works there without a letter of appointment. Can we say the person is an employee? Kothuroti Kada comes under the Shopon Office Employees Act.
But the contract of employment can be verbal also, according to the Industrial Dispute Act.
Very good, right? So according to many of our labor statutes, there is no need to have a written letter of appointment. Written letter of appointment is not a mandatory legal requirement to create employee-employee relationship. And also when it comes to contract of employment, now we have many emerging issues because now we go for technology-driven employments, right? So for an example, there was a case. When you have time, you can go to the internet and get a case, Uber London Limited case. The issue was whether the Uber taxi drivers were workers, right? Finally, the court decided they were workers, right? So now it becomes another emerging issue because now we go by technology-driven employments. Workers are working from home and we have various forms of work arrangements. So when it comes to all these different forms of work arrangements, the issue will be whether the employee-employee relationship exists, whether the person who provides the services is a worker or not. There are tests and all. We will discuss those things right under this module. Also, types of employment, another issue. But anyway, I have discussed with you earlier. Now, after this minimum retirement age of workers act, there are many inclusions by the legislature with regard to the types of employments and all. When it comes to the terms and conditions of employment, for the first time in the history of Sri Lanka, the minimum retirement age to the workers in the private sector has been legally defined that we have discussed. Also, we have the Shopon Office Employees Act when it comes to the workers who work in shops and offices. When it comes to the workers who work in other workplaces, the wages boards have been established. And if wages boards have been established for those categories of workers who work in other trades, then the wages boards decisions will apply when it comes to their terms and conditions of employment. Of course, there are categories of workers who are not covered by the Shopon Office Employees Act. At the same time, there are no wages boards established for them, right? There are categories of workers. So that is mainly about the terms and conditions of employment. Then health and safety matters we discussed. When it comes to the health and safety matters, we have the factories ordinance, right? It provides for health, safety, and welfare of the workers. But again, when it comes to the factories ordinance also, the factories ordinance is the only labor legislation in Sri Lanka which provides for health and safety matters. But the factories ordinance applies to the workers who work in factories. Of course, there's a broad interpretation to the word factory, but workers who work in other workplaces other than factories do not have any legislation to deal with their health and safety matters. There's a gap or lacuna, right? Right. So about 15 years ago, there was an attempt to go for a new legislation, Occupational Health and Safety Act of Sri Lanka, applicable to all workplaces, but it has not yet been passed. So the factories ordinance also has some gaps. For an example, during the pandemic period, we couldn't apply any of our labor legislation to deal with the COVID pandemic. Then the Minister of Health had to go for a gazette regulation under the quarantine ordinance in October 2020 to gazette a regulation with regard to the obligations of the employer to take measures to protect the workers from the biological hazard. So when it comes to biological hazard, we don't have provisions even in the factories ordinance to deal with pandemic now, right? So the factories ordinance comes under the health and safety matters. Also the workman compensation ordinance, that is about payment of compensation for accidents and occupational diseases, right? Also we have social security benefits like EPF, ETF, gratuity. So we have statutes dealing with those matters: employees provident fund, employees trust fund, payment of gratuity. When it comes to trade union rights also, we have many legislation, right? Trade unions ordinance, and also the Industrial Disputes Act. When it comes to the workers in the private sector, their trade union rights are guaranteed by the Industrial Disputes Act. Section 32 capital A has been incorporated by an amendment which came in 1999. After that, the workers in the private sector have the legally recognized trade union rights. They have the right to form a union, right to join in a union, a right to engage in trade union activities, protection against anti-union discrimination, also right to collective bargaining if the union represents 40% of the workers. Also the trade union actions and all we will discuss later. But of course there are limitations to trade union actions also, right? Then if there are disputes at the workplaces, then we have the Industrial Disputes Act. Actually, our Director General also explained about the importance of industrial harmony, industrial peace in the country. For that, we have many statutes, in particular the Industrial Disputes Act, which deals with maintenance of industrial peace in the country. So there are many mechanisms coming under the act. We have collective agreement, collective bargaining, collective agreement, conciliation, arbitration, industrial court, and also labor tribunals. These are the mechanisms we have. Then when it comes to termination matters also, there are many cases. Of course, there are different types of terminations. Constructive termination, the employer creates the conditions which force the worker to leave the workplace. Vacation of post, disciplinary terminations, termination for misconducts and all, non-disciplinary terminations, closure of the business, reducing the workers. We have the Termination Act. So those things we will cover under termination of employment. Then we will also go for some ILO standards and all, wherever it is relevant, because the ILO conventions and ILO standards also become relevant. Now, the recent ILO convention is ILO Convention C-190 about elimination of violence and harassment at workplace. But of course, when it comes to our labor legislation, there are many gaps also. For example, when it comes to discrimination in employment, we don't have any specific provision applicable to the private sector employments, in particular at the time of recruitment, if there is any discrimination. Also, we don't have provisions in our labor legislation to deal with violence and harassment at workplace. For an example, when it comes to sexual harassment at workplace, we don't have any provision in any of our labor laws to deal with sexual harassment at workplace. But of course, we have the penal code and all. So when it comes to those situations, how to deal with those matters, we will learn under industrial relations and all, right? So finally, I would like to say that, when it comes to the course in labor law, right, under this program, right? So under National Diploma in Industrial Relations and Labor Law Applications, it has many modules, Under the modules, these modules are very broadly designed modules. There are so many branches when it comes to the subsections. The branches we are going to discuss many things. So basically it covers a very broad area, wide scope. So, but as I said earlier, when it comes to labor issues, always the labor issues emerge. Sometimes we can't find the answer in the labor statutes, right? During the pandemic period, there were many labor issues that emerged. For them, we couldn't find the answer in the labor statute, but we had to apply the common sense, and also we had to go with some mutual understandings, right? Because labor, when it comes to labor matters, always the labor issues emerge. When it comes to some labor issues, because I have written 2 articles, later I will share the articles. One is about the COVID-19 and the emerging labor issues that I wrote at that time. Another one I wrote about COVID-19 and termination of employment. Another one I wrote during the COVID period, masking face at workplace, unmasking the labor of Sri Lanka. That means simply whether an employer can terminate a worker for not wearing a face mask at workplace. So I wrote that during the high time of the COVID pandemic. So what I want to say is we always have issues that emerge in labor law. But when it comes to the labor issues that emerge or exist, we should know labor law. But of course, I don't say you can master the subject. At least you should have the basic understanding and good knowledge to know what to do, what not to do. Because sometimes you may cause some irreparable damage to the organization. Because by the time you go to the legal forum or to the consultant or anyone, it may be too late because already you have caused a damage. So to avoid those things, you should have a good understanding of labor law. So finally, I would say when you follow this program, the National Diploma program, right? Because it covers very broad areas, many topics, and many labor laws, many regulations, many cases will come under this area. Then at the end, you will have a recognized diploma. At the same time, the knowledge that you should have, also the skills also you have to have. Because when it comes to the teaching also, I always say it is not spoon feeding every time, because we have to develop the skills of the participants to independently identify the relevant laws and interpret the provisions and apply to the problems. So those skills we have to develop. Otherwise, it is no use, because I repeat again, when there is a problem, you have to identify the relevant law, then you have to identify the relevant provision, then you have to interpret the provision, then you have to apply that provision to the problem and solve the problem. So that those skills also are very important. We have to enhance those skills also, of course, definitely. So at the end, you will have the diploma, very valuable diploma, and you will have the knowledge, and you will enhance your skills and all. Of course, the attitudinal change also will be there, right? With all, you could be a very successful human resource manager, right? So with that, I think I have taken too much of time. But anyway, I will meet you when it comes to the diploma. So when it comes to the specific topics and all, I will discuss in more detail. So with that, I would like to conclude my short presentation in the area of importance of labor law. Thank you. Good night.
Thank you, sir, for your valuable presentation. We are enlightening to your valuable presentation. Always you help to us and us to deliver world-class training in Sri Lanka. So thank you very much, Professor.
Thank you. Thank
you. We appreciate your time taken to you deliver this lecture. Thank you, sir.
Thank
so,
you.
I would like to invite I would like to invite Mr. Lalit Kumara Wickramarachchi. He has completed BSc and MSc degree and also diploma in business management. In the profession, he's an attorney at law and LLB Sri Lanka. He completed his LLB degree in Sri Lanka. Yeah. Furthermore, he is a consultant in labor and environmental law, lecturer in labor law, and specialist for the labor tribunal cases. I always appreciate your commitment and hard working towards Nile's activities. So I cordially invite Mr. Lalit Kumara Wickramarachchi to deliver his lecture. Thank you, sir.
Thank you. Good evening, Mr. Suranga, Director General. Can you hear me?
Yes, we can hear you.
Okay, good evening, Mr. Suranga, Director General of Wildlife and Niles, and my panel colleague, Professor Sarveswaran, and all other members who participated here. Really, Mr. Sarveswaran, Professor Sarveswaran explained about the very important theories, very important statutes, which is relevant to the labor law. And I would like to explain in practical things. That means what is happening in the courts, especially labor tribunals and labor department. And if you are not satisfied with the labor LT judgment, of course, you have to go to the appeal level. That means Court of Appeal, Supreme Court. So what is happening when we are dealing this practical level? Really, what do you mean courts? Why do you need courts? Forget about the labor law. Why do you need courts? You need the courts because there is a dispute. If it is a labor dispute, if it's an industrial dispute, of course you need the labor court. That means labor tribunal. So under the Industrial Dispute Act, there is a provision to go for the labor tribunal any employee who feel he was terminated or constructive terminated. So the only thing is you must have a good labor law knowledge and also practical knowledge. That means what is happening in the courts. In law, you know, there are two main parts. One is theory law. That means a statute where you can find. Other one is case law. So case law, of course, you have to study from the courts. That is practical thing. What is happening in the courts, right? So if there's a dispute, industrial dispute, how we can sort out? First of all, you can negotiate, but if the negotiations have failed, definitely it will go to the courts. Initially, it's for the labor tribunal. So then both parties must have a good knowledge about the labor law. Both parties mean both employers and employees must have a good knowledge about the labor law. So as Professor Sarveswaran explained, under the Termination Act, there is a provision that to terminate the employee in two ways. One is the resignation. Under the Termination Act, the employee can give the resignation within 30 days, between 1 month time. And once the employer gets the consent of the employee, he can give the approval for it. Then it's a normal termination of the appointment because it is a resignation. Now, there's another option under the Termination Act. The employer can make the request to the Labor Commissioner General and get the approval to terminate the employee. So these provisions comes under the Termination Act. That is a theory. Now, what is happening in practical? I think if you are an employer, you may have experience about that. So you are getting the employees given the resignation for you, and you have already approved. After he has given the resignation letter, you approve. So it comes under the Termination Act. There's no problem. But practically what happened? Most of the time, those employees go and complain to the labor tribunal, saying, you have collected that letter as an employer, you have collected that letter by force. In that case, so what is the result? That is constructive termination. Then you are liable to answer for the labor tribunal, right? So why these things happening? Because because lack of the proper channel of the labor law, how to handle the poor knowledge of the handling in properly labor law, right? Yes, if you according to the Termination Act, you can accept the resignation letter given by the employee. But if later on, if he goes to the labor tribunal complain that it is taken by force, you are in a trouble as an employer, right? Then there is a case. So that is one point. That means you must know the labor law, how to handle it properly. Then another point is disciplinary inquiries. You know, if there is a disciplinary termination, it not come to the provision of the Termination Act. If it is a disciplinary termination, it is completely separate thing, not comes to the Termination Act, right? So then there's a problem for private sector people, especially private sector people. So what is the act or ordinance to handle the disciplinary inquiry in private sector? So what is the statute to handle the disciplinary inquiry in private sector? Somebody can answer?
There is no any provision, sir.
Very good. That is the issue faced by the private sector people, especially employers. There is no statute to handle the disciplinary matters in private sector. Then how can you do this? If you are an employer, if your employee did the disciplinary matter, violate the disciplinary regulation in your institute, so you have to take the disciplinary action. But once you take the disciplinary action, if he won't accept that, definitely he will go and complain to the labor tribunal and the labor department also, saying he was under constructive termination. Then, if there is no law for the handling disciplinary matters, what you should do is, you have to check what are the things applied by the applied in practical. What do you mean practically? Applied by the courts, labor tribunal, court of appeal, and Supreme Court. What is the main theory they apply is rule of natural justice, right? So then, if you have followed the process of rule of natural justice to handle the disciplinary matter in your in private sector as an employee of the private sector, you won't be in trouble in even labor tribunal as well as the court of appeal and the Supreme Court, right? So I would like to take example, very recent judgment delivered by the Supreme Court, that is Supreme Court Appeal number 60, 2018. Supreme Court Appeal number 60, 2018. That judgment was delivered 2022, May 5th. That means the judgment was delivered in last year, May. Very recent judgment. I will repeat the case number for the benefit of who study in the law and as well as the benefit for all. Supreme Court Appeal number 60, 2018. Right? So what that judgment says regarding the disciplinary termination as well as other terminations, right? the judgment clearly say, if the employee denies the termination, burden of proof to the employer. See the risky situation faced by the employer, right? If the employee denies the termination, right? That means resignation, then burden of proof goes to the employer. What do you mean burden of proof? Burden of proof means if you're saying something, you should prove it with the evidences, right? Now, if you are going to terminate your employee due to the disciplinary matter, you must handle the disciplinary inquiry improperly without violating rule of natural justice. What do you mean rule of natural justice? Clearly it says the one rule, you can't be a judge in your own case. You can't be a judge in your own case under the rule of natural justice. And you should listen both parties and given reasonable time. Those things included in rule of natural justice. Now, what is happening in practical? If you are an employer, if you want to do the disciplinary inquiry, most of the time, according to the experience gathered by us, the cases received by us, most of the time, as an employer, you are selecting inquiry officer from your own institute, own company. Then what happened? You are violating rule of natural justice. What do you mean? Violating rule of natural justice? It says, rule of natural justice says, you can't be a judge in your own case. Then, if you selected an inquiry officer from your own company or own group of company, what is happening? You're going to be the judge for your own case. Then you are violating rule of natural justice. Even the employees did the disciplinary violation in your institute. If you selected an inquiry officer in your own company, maybe retired officer in your own company, maybe senior officer in your own company, maybe a person in your group of company, what will happen? You are violating the rule of natural justice. Then, of course, when it goes to the labor tribunal, if after that disciplinary inquiry, if you are terminated your employee, when it goes to the labor tribunal, definitely labor tribunal will decide and say it is under constructive termination because you are violating rule of natural justice. Then what you should do? What is the best thing to do as an employer? What is the best thing to do? If you want to do something without violation of rule of natural justice, what you should do?
You should get somebody from outside to do the inquiry.
Need to select a third party.
Of course, you should select a third party person to do the inquiry. Another important thing, that is also practical thing, right? Most of the employers, they don't allow to defending officer. Who is defending officer? From the disciplinary inquiry, if you are listening for the both parties under the rule of natural justice, if you are listening for both parties, you should allow the accused employee to bring a defending officer. That means you listen for both parties. But what happened in practical? Most of the employers, they don't allow to defending officer. Do you agree with me or not?
Just can I ask you a question, sir?
Yes.
The defending officer means maybe you bring a lawyer to argue your point, is it? What do you mean?
Maybe. No.
Or somebody else.
It may be a lawyer or somebody else, maybe a union leader, right? Maybe his friend. No problem. There is nothing to say. There is no compulsory thing to say. Defending, you should bring a lawyer as a defending officer. Okay, first of all, I will explain who is defending officer. Defending officer means he is the person who is defending accused on the disciplinary inquiry. You know, disciplinary inquiry is something like it is very similar to court, not the court, but similar to court. That means there is an inquiry officer who is deciding the matters. There is a prosecuting officer who is bringing the disciplinary matters, the relevant disciplinary matter to the inquiring officer who is submitting that. There are evidence. There are people who is giving evidence, and there is an accused person. That is the picture in formal disciplinary inquiry, right? In that scenario, if the accused person says he thinks that he is unable to submit his submission by personally, he may feel that he needs the person who helped to do this. That means he is thinking about the person who defends him. So then if he brings the person like that, is called defending officer, right? So defending officer may be a lawyer, maybe the friend of accused person, may be a union leader, maybe a union member, or any person who wished by the accused person. But my point is, most of the employers not allowing to the defending officer. So I think most of the employers doing that because they afraid for the outside person to come to this scenario. But the role of natural justice, if you listen for the both parties, you should allow it, right? Why I'm telling like that? If you allow the defending officer, then that employee cannot getting very difficulty to go and complain to the labor tribunal that that his termination was under constructive manner, right? Because he has given enough chances to prove his evidences and all other facts to safeguard him. So if the employer allow those things, right? So he is fully bounded and he cannot go and complain later on. So that is the one part. Burden of proof if it is a disciplinary termination, right? So now in case of transfers, again people come and complain, and those transfers, you don't believe, the cases for the transfers, it came to the labor tribunal on the beginning, then sometimes it appeal up to the Supreme Court. Transfers, right? Now Professor Sarveswaran explained clearly, transfer mean even in the same directors, if the group of company, the working place is different, it's going to be a transfer, right? So without consent of the employee, if you did the transfer, the employee can challenge it as a constructive termination. So another one is what the superior courts explaining regarding this transfer, right? I will take the same example I mentioned earlier. That is Supreme Court Appeal number 60, 2018. Under that judgment, what the Supreme Court says, if there is a transfer, whether it is legal or illegal, employee has to comply and complain. That is the theory explained by the Supreme Court from this judgment that is delivered in 2022. Even in the judgment in 2020, Supreme Court Appeal 101 upon 2014, right? The same thing explained, comply and complain. What do you mean comply and complain? If you got the illegal transfer, most of the employees that they are doing, what they are doing is they are not reporting the new place, and they are staying in the home without reporting. Sometimes they are sending medical certificate or telegram, and sometimes they are not sending that also. They just make an appeal and stay in the home, not reporting, right? What the argument is, transfer is illegal. But you know, what the Supreme Court feeling is, what the view of the Supreme Court is, it should be a comply and complain. What do you mean comply and complain? As an employee, you should comply for the superior order. Then after comply, that means you have to report the new station, new office or new branch, new place that you got the transfer. Then you must report to your employer that you are not happy with the transfer did. You are not accepting the way of did the transfer, and you are reporting here because of as the obedient worker, but you are going to complain regarding that matter. So that is what we explain, the comply and complain, which is the theory introduced by the superior courts. I told in the earlier, law including two parts, theory law and the case law. Theory law means what the statute says. Case law means what the superior court says. Superior court means Court of Appeal and the Supreme Court. And what the superior courts explain about the transfer, that is comply and complain. Okay, and I'm talking about the disciplinary matters, which is a very severe problem for the private sector, where you have to face lot of disputes, lot of inquiries in the labor department, as well as the labor tribunal, and the after the appeals from the Court of Appeal and Supreme Court. Most of the time, employers has to have a burden regarding these issues, and also as well as the employees also. And that is disciplinary matters, right? Under the labor law, the only thing is there is no dispute, there is no relevant statute to handle this dispute. Therefore, you have to always follow the case law, and you have to have a good knowledge what is happening in the field. Field mean in the courts, when there is a labor tribunal, and also appeal level in the Court of Appeal and the Supreme Court, and also labor department, what is happening, those practical things. That is under the termination. And also transfers, you must have a good knowledge of rule of natural justice. While there is no statute to do it, then you must think about the rule of natural justice. And letter of appointment. Most of the people thinking this letter of appointment is the compulsory thing. Under the, under the contract law, if there is an offer and if there's an acceptance, then there is a contract. letter of appointment also one way of contract, because employee is offering that and employee is accepted that. But what is the difference between the agreement of under the contract law and the letter of appointment? What is the difference? I'll repeat the question. Letter of appointment also some sort of an agreement. That means offer by the employer, accepted by the employee. Under the contract law, there are agreements for various business purposes, right? So what is the difference between a contract law agreement and the letter of appointment?
So maybe the labor, because of it's an employee-employee relationship, the labor law supersedes the contract law. So people go, if you go to a civil case, you will not get the compensation of what you require. But if you go to labor courts, under arbitration or whatever means you take, definitely you will get something better, because labor law will interpret and give you something an equitable justice system. So you can definitely get something more.
Yes, very correct. Then what now if you consider about the normal contract law agreement, as example, two companies having an agreement regarding some contract. In that situation, both parties is two companies in the same strength, I mean same energy. The one person will not weak and another person not have a big strength. Both companies will come to an agreement regarding the business purpose. So both companies, both parties having the same energy, right? No one is weak. But considering letter of appointment, what is the level? When you are accepting your appointment by saying you agree to the terms and conditions of the letter of appointment offered by the employer, what is the strength? What is the energy as an employee on that stage?
Employee is having less bargaining power on the appointment letter acceptance?
Very correct, very correct. Really, especially third world countries, there's a big demand for the job market. As an employee, if you are not willing to accept that letter of appointment under the condition made by your employer, there are 100 people, not 100, there are more than 1,000 people behind you to come and accept that letter of appointment under that conditions. That is the situation faced by the especially third world countries, because due to the huge demand for the job market, right? So considering those facts, especially Industrial Dispute Act given a big chance for the employee. You can just check the Industrial Dispute Act, section 31B, subsection 4. I'll repeat it. Section 31 of the Industrial Dispute Act, section B, 31B, subsection 4. It clearly says, 31B4, it clear under the Industrial Dispute Act, it clearly says labor tribunal is not bounded with the letter of appointment. Now, most of the employees who comes to us regarding the cases, especially labor tribunal cases, most of them are working in very small places, maybe shops and the places, very small thing. Even in the big places, they come and say, "Ayyo mahatya apita patte lipiyannan dunne naha." We have not received letter of appointment. But you see, under the provision of the Industrial Dispute Act, there is no bound by the labor tribunal with the letter of appointment under the section 31B4. Why that provision goes to the mention in the Industrial Dispute Act? Because of these things that mean when you are signing your letter of appointment as an employee, you are very weak on that stage. Whatever the condition made in your letter of appointment, you are signing and accepting the offer given by the employer. Therefore, if something happened, right, whatever mentioned in the letter of appointment, the labor tribunals are not bounded with that section mentioning the letter of appointment offered by your employer, right? So that is some sort of fortunate for the employees. But what do you feel in case of employers regarding that section? Now, as an employer, while you are giving your letter of appointment, you are mentioning so many conditions. You should be transferable anywhere, any place in the country without notice. You will be terminated during the probation period without notice, like that. As an employer, you are putting so many conditions in your letter of appointment. And finally, you are very happy because your employee has signed and say, okay, I will accept for these all conditions mentioned in the letter of appointment, right? So after having that letter of appointment, you are keeping in the file as an employer and you are very happy because you can do anything because everything mentioned in the letter of appointment. But when it comes to the labor tribunal, Industrial Dispute Act clearly says LT is not bounded with that condition. Then what happened? It is not a recognized document for the labor tribunal, right? Then, as an employer, what is your situation? What is your safeguard? Right? If under the section 31B, subsection 4, if the labor tribunal is not bounded with the letter of appointment, I'm asking as an employer, what is your safeguard? If you have already terminated your employee due to the disciplinary matter. Nobody can answer?
They should follow the label, sir.
Of course, you are very correct. If you have a good knowledge in labor law, including how to terminate the person, how to transfer the person, how to appointing the person, how to promoting the person without getting the burden for your head as an employer. If you know it, right, then you don't have a problem, right? Because you may have a disciplinary code in your own place, own company. That is something internal, right? You may have, definitely you have a letter of appointment and employees sign and return it. You feel it's a very powerful document. But if you are not have a good knowledge of labor law, including all the rules, especially role of natural justice, and how to prove your things. That means what are the burden of proof, right? What are the things that you have to prove in the courts? All theories are there. All statutes are there, right? But you know how to implement those things in the courts. That means you must have a good knowledge of the statute as well as the good knowledge of the case law, especially the This is a modern world, right? Now I would like to show the one lecture I handling today under the coordination of the can I share the screen? I will show one lecture handler done by today. Yes, there is. See. Now there's a question. Can the company representing the company lawyer as a prosecuting officer in disciplinary inquiry? Of course, there's no problem. There's no problem. If you are bringing the company lawyer as a prosecuting officer in domestic inquiry, why do you not allow to defending officer? Or if the accused employee wants to bring the lawyer as a defending officer, why are not allowed? Right? So that is a good question raised by somebody, right? So the best thing, you can bring the lawyer as a prosecuting officer. Also, if you need the very free and fair domestic inquiry, you can bring the lawyer as an inquiring officer. And if the accused employee asking the lawyer as a defending officer, right? Why don't you stop in that? Is there legislation for independent contractor? Okay, I'll explain it, right? So what I'm talking now is it's a modern world, technologies, serious to develop, right? Yeah, now, using a mobile phone, you can video, you can record audio, video, and there are CCTV options and computers. You are using computers. Most of the time, you are using softwares, not like earlier days. The earlier days, even for the documentation, you are using hard copies. Now it's changed. Now you are using the IT knowledge, emails, WhatsApp, lot of modern technology developed under the IT, right? Now, if you are using these modern techniques, right, you must know how to handle it in practical level, right? Okay, there's a dispute in inside your premises, working premises, right? You have a CCTV camera. So somebody has already recorded that incident, right? Then you must know how to use this recording, maybe mobile phone video, maybe CCTV video, right? Maybe any other way of recording, right? You must know how to produce this as evidence to the courts, right? And take it as evidence on the benefit of your part. I mean, for the support of you, right? So because of that, there is a special act, the Evidence Special Provision Act number 14, 1995, right? So according to this act, there is a procedure to follow. If you have a video recording, audio recording, if you are going to produce this as evidence in the courts, right? Especially labor matters, if you are going to produce this as evidence for the LT, right? There is a procedure. What is that procedure? Before 45 days of the inquiry date. That means if you are going to produce this as evidence in the courts, so before 45 days of that particular days, you should inform it to the opponent party that there is a CCTV recording, there is a computer recording, or there is a mobile phone recording, we are going to produce this as a evidence in the labor tribunal. So you have to inform the opponent party before 45 days. If you are unable to do it, there is a clear objection by using this evidence special provision act, and you will be unable to produce that evidence. If these things happen, what happened? If it is so, what happened? You may have a good evidence with your CCTV camera, with your mobile phone, but you will be unable to produce it in the courts. Then you will be failed. Then, therefore, you must inform them to opposition before 45 days that you are going to produce this as evidence, right? Then, after informing that, the opposition party has the right, according to this act, to reach your original and check it, right? Supposing you are going to produce the CCTV camera recording as evidence on behalf of you. Now you have informed to the opponent that you are going to produce this as evidence before 45 days. Now that your opposition party has the right to reach your original and check whether it is clear, genuine original or created one. Then within 15 days time, you will apply same date period for evidence at domestic inquiry. No, really, from the domestic inquiry, there is we don't need to apply those dates because I am talking about the courts, right? For the domestic inquiry, you can inform them that you are going to use this recordings, but there is no particular time period in domestic inquiry. I am talking about the courts, especially labor tribunal, because most of the private sector people are getting burdened while they are not following the proper rules. They definitely will have a big trouble in the labor tribunal. That is why I am explaining what is the practical things, what is happening in labor tribunal, what is happening when you are appealing cases against the labor tribunal judgments in Court of Appeal and the Supreme Court. So I want to explain the practical things and also disciplinary inquiries. So I want to explain you the practical things that you have faced and that you are getting troubles as an employer as well as the employee, right? So, right. Now, you inform before 45 days for that particular party, we are going to produce this as evidence. Then they have a right to reach for your original. Then they will request within 15 days time that they need to check your originals. Then within another 15 days time, you should allow them to check it, whether it is a genuine original or not. Another important thing is under this act, you must prove to the courts, to labor tribunal and the higher courts, you kept in a safeguard with that recordings, and nothing changed, nothing altered, and all those things you should prove, right? Then very simple process, under the evidence ordinance, if you want to prove something, you must need at least 2 evidences, right? But according to this, under the evidence or the Special Provision Act regarding the video and audio recordings, it is very easy. Just produce that camera recordings using the technology, and very simply you can prove it, whether your employee has done a mistake or not, whether these things happen in your working premises or not. Very easily you can provide it. What you have to do is you must know a good knowledge of this act, which is applicable for labor law, right? Now, very simply, everybody says there is no law for the disciplinary matters in private sector, but there are so many alternative laws. Not directly involved, but indirectly involved, right? I told you one is rule of natural justice. The second one is Evidence Special Provision Act, number 4, 1995. You know, it is indirectly involved. We can use it for your disciplinary matters. You have whatever the dispute. Supposing there's a huge protest inside your working premises, and a lot of damage is done, right? Various things happening like that. So if there's under the trade union ordinance, so employees has the right to take the trade union actions, right? But they have no power to damage the properties, right? Hit the people, no right, right? But if those things happen, the CCTV recordings, phone call, mobile phone recording is the most important thing to use as evidence. But most of the people don't know what is the procedure to produce these evidences, right? And I would like to mention another Supreme Court case, right? That is Supreme Court Appeal 94/2020. So what the Supreme Court says, right? In case of the burden of proof, right? If the employee denies the termination, right? It goes to the employer to prove that he did everything according to the law, right? So that is Supreme Court Appeal 94/2020, right? So then if you are going to prove it, that means burden of proof comes to the employer. So if you're going to prove it, how you can do it? You are going to bringing 2, 3, 4 people to giving evidences in the labor tribunal or court of in later stages. If there is a contradictory between among that evidences, definitely you will fail. But if you have recordings, CCTV, phone call, everything, especially Facebook, that's also social media, right? So those things you can use as evidence if you know the knowledge of this act, which is relevant to the which you can use as the law for your labor matters, right? And as I explained earlier, within 45 days you should inform. Then within 15 days they may request to go for a check for the originals. Then within another 15 days, right? You should give the permission to check it. After that, you can use it as evidence. After the following that process, that means informing them and receiving their request to check the originals and allow him to do it. And if you kept in your safeguard without altering, without damaging the things, and if you follow in those things, you can use it as evidence, which is going to be a very simple process to prove your part. So that means if the burden of proof comes to your head, but if you can use this law, knowledge of law, these laws, you are in a safeguard. So finally, what I want to say is, it is the labor law and also the practical thing, case law, and knowledge of these both, very important. If you are an employer, if you are an employee, also if you are a HR manager, if you are working in a legal division of the any working place, that is very important. Are there any special provisions when it comes to the employment of legal practitioners as intermediates with Swedish also applies to them? Okay, I will explain to you later. Right? So what you can, what I can say is, if you have a good knowledge about the both theory mean all the statutes under the labor law, and the good knowledge of the case law. Case law is the practical thing, practice. Where the theory apply in the course, that is the practice, right? So from the, from the Court of Appeal and the Supreme Court, the judgment delivered from both superior courts, we can use as an example for any course in the country, and also the same course for these same cases in later on. So if you have a good knowledge, both theory and the case law of the labor law, you will be the success person, even you are an employer or employee. The employee is bound to give the original video copies. Yeah. Yes, you can give the copy, but you should allow your opposition party to check and come and check your original. Otherwise, they can say this is an altered one. The employee is bound to show, not employee, who is the person who is expecting to produce the video evidence, he is bound to show the original for opposition party, whether you are employer or employee, right? So finally what I want to say is, right, if you have a good knowledge about the labor law, what labor law means, both theory law and the practical. Practical means what is happening in the courts, how you can implement the theory law in the courts, right? You will be the success person. Can employer refuse to sit for an inquiry objecting the company officer sitting for the inquiry? Really, you can make the, from the disciplinary inquiry, there are two types of objections: preliminary objection and ongoing objection. As a preliminary objection, you can say this inquiry is done by the company officer. Therefore, I have a preliminary objection regarding that. But don't go out from the inquiry, then they will do it, as a one-party manner. But you can write down that your objection, and you can take it as a evidence against the employer when you are handling the matter in labor tribunal. So finally, what I want to say is, knowledge of this labor law with the statutes as well as the practical thing, that means what is happening in the courts, that means the case law is very important. So if you follow the courses in NILES, I have my experience in the last 10 years doing the lecture as the all these important courses handled by the NILES. You will be able to gather this knowledge, both theory laws and also case law, because getting a theory law, that means to get the knowledge of statutes, you can do it while reading a act. But again, it's a little bit difficult because getting a knowledge of the law, not like other subjects, you must get the support of the expert, like Professor Sarveswaran. You must have you must get the support of the superior expert person. And also, in case of case law, you must have a consultation from the person who had the experience in the field. So these both benefits you can gather in one place where we can call NILES, because it is the place for conducting most important courses, diploma in labor law and diploma in HR management, and various other short courses, various 1-day and 2-day courses, and weekly courses. So various type of course handling by NILES. So you can gather this very important knowledge of the labor law, both statutes, that in both theories and also practical things. What is happening in the course, because those lectures conducted by the expert panel selected by the NILES. So not only that, you are getting a very valuable certificate which is recognized by the national and international level, because it's handled by the under the Labour Ministry of the Sri Lankan government. So I would like to conclude my session, and thanks for listening all. Especially thanks for the Director General of the NILES and other staff, including Mr. Priyantha, Assistant Director. So finally, I'm going to stop my session, and I would like to answer for any question when the that forum starts. Thank you. Good night.
Thank you, Mr. Lalit Kumara, for your valuable lecture. I invite our participant to take this time to as a Q&A session. You can start now.
I have one question, because I am now working at the labor department. I want to follow this course, but problem is can I pay the course fees in installment, and how many installment I can get it?
Yeah, you are eligible for the pay the course fee in 8 installment. 8 equal installment. You can pay the course fee. In it's mean 14,000 per first installment. First installment is 14,000. Did you get it?
Sorry, I couldn't get it because some interference.
Yeah. You can pay the course fee in 8 installment. It means the first installment is 14,000. In the registration, you can pay 14,000, and after that there will be a 7 installment, and there is no registration fee and any other payment.
Okay, thank you. I got it.
So I have one suggestion. Could you please improve this course up to any advanced level? This is a diploma level, advanced diploma, or any degree level, NVQ 6, 7, like.
Yeah, we have a discussion with the TVC to upgrade this diploma to another year. Then we can award a diploma, advanced diploma in labor relation and industrial relation and labor law. So we have a discussion. I think when you are completing this diploma, we will be in a position to offer the advanced diploma. It's equal to NVQ level 6. NVQ level 6 means a second year of the university level. So meantime, we are trying to develop in some collaboration with the foreign university to offer a degree and postgraduate degrees. When some student completed this course, we can accommodate then the relevant level. I mean, if you have completed level 6, NVQ level 5, then you can start the degree program second year onwards. If you have completed the degree program NVQ level 6, you can complete the last year or final year of the degree program. That's why that's the process. We are having a discussion about the collaboration in foreign universities with foreign universities. Up to now, you can start this level 5 program, and definitely in next year we will be in a position to offer level 6 program, advanced diploma. Any other question or regarding the program or labor relation issues? Our resource person is all with us, Professor Sarveswaran and Mr. Lalit. They will handle the technical matters. And if there are any question relevant to the program, all of us can ask, can give the answer.
Sir, I have a question with related to the program. Could you all consider a online diploma, like the same diploma on an online platform for the people who are unable to attend the physical lectures at Nara Hempita?
Yeah, same program we are delivering through the online platform. Like we have web facilities, webcam facilities, and we are delivering the Zoom platform. And our recording will be also given. Same physical program delivered through the online platform. No separate online program.
That means physical attendance is not required for the people who cannot attend.
Physical attendance is not required, but for the examination physically at the moment, according to the TVC guideline, physically you have to attend.
Okay, sir. So the classes will the students can attend either physical or online.
Online.
Am I correct? Okay, thank you.
Correct. Physical classes mode will be telecast as online classes.
Okay, all right. Thank you, sir.
Mr. Lalit, you can, Professor Sarveswaran.
One more question from me. That is, whether there are any reference materials for the students' benefits?
There are so many reference material based on the modules. In the TVC guideline, we will share the TVC guideline. It shows that what are the references material to come in that module, relevant module. So we will share that document with you, and in that module, if we consider particular module, it clearly says that what are the topics we have to cover. Very comprehensive document. We can share it.
Also, may I add a small thing? According to my experience in last 10 years, so many HR managers and especially staff of the labor department followed this course. Now, I'm very happy to say I can meet in the courts, and from the labor tribunals, there's option to appear for the agents. That means not a lawyer. On behalf of the employee, the agent can appear. So I met so many students who followed the diploma in NILS, acting just like a lawyer. It's a sharp knowledge. Really, I'm happy to, and I'm proud to be a lecturer of these students, but they are really senior officers in their institute, just like HR managers and those categories. But they appear in the labor tribunal just like lawyers. I'm very proud to say products of the NILS.
Any other question regarding the program or technical matters?
So what will be the evaluation model, evaluation, how it would happen, like all examination based, or are there any
No.
assignments also?
Yeah, assignment based and examination. Normally, if you consider the first module, Introduction to Labor Relations, it gives the 40 marks for the assignments and 60 marks for the final examination. That's why TBC they gives the guideline in the NVQ level 5 criteria. Normally, every module have assignments or practical or role play, some kind of or presentation. In addition to that, final examination. Marks divided according to basically 40, 60. 40, 60, sometimes 50, 50. Is it clear?
Yes, it's clear, sir. Thank you.
Any other questions? Okay,
now let me 1 minute excuse. Somebody in the chat box asking the question, sir, when you are planning to start the Sinhala medium, I think Mr. Suranga, you can answer for it. Somebody is asking when you are planning to start the Sinhala medium course.
Sinhala and Tamil medium program will start May second week of the May 2023, and Sinhala all and Tamil medium both are NVQ level 5 program. That's why in the previous session I told that we have get the special approval from Treasury Education Commission to issue the NVQ level 5 for our Sinhala and Tamil programs. So we are very proud of that. Sinhala and Tamil medium participant also can obtain the NVQ level 5. If in some cases, if we the earlier discussion, some are asking they are going to abroad, how to continue. If they are unable to, sit the exam, we will try to make another option. We can issue a diploma, but there is limitation to offer NVQ level 5. We have to discuss with that option. For examination, they will do another assignment or some kind of, but they are not getting the NVQ level 5. If they fulfill the diploma, some kind of diploma requirement, we can give diploma, but not the NVQ. My advice is go to NVQ level 5 and the diploma, get the 2 certificate. That's my idea and my advice.
Mr. Suranga, from the chat box, another question raised. What are the entry requirements?
Entry requirement are O-level, A-level, and higher education. If you have O-level with the experience, we can consider the case by case.
Another question raised by somebody. Somebody else raised another question. Please share the contact details for more information. I think Niles have a leaf. If you can share it. They're asking to share the details for more information.
Okay, we will share our details and contact details and the NVQ curriculum, and you can study how important and how the depth we have in this course and how from which you can study. We will share. Thank you, Mr.
What is your pass marks?
Pass mark are normally 40, but in some cases I have to EVD because we are first time we are giving this NVQ level 5. Maybe sometimes it may be 50. We'll check and let you know.
Also, will it be 50% for each, like for example, assignment 50% as well as the exam 50%?
Yeah. That's
So
right.
that means you're looking for minimum threshold to pass.
Yeah. Minimum threshold. We will let you know the 50 or 40. We'll let you know. Okay.
Another question, Mr. Suranga. Somebody asked, the lectures conduct in the same lecture panel for Sinhala medium. I mean, they have a worry whether English medium staff handling the lectures for Sinhala or not.
Most of time, same lecture panel, as you know. Professor Sarveswaran can deliver lectures in Sinhala, and you are also delivering one of the key resource person in Sinhala medium, and Mr. Ranavira. They can both deliver lectures. When you go to the Sinhala medium, Tamil medium diploma, we have separate lecture panel. But the Sinhala and English medium, same lecture panel.
According to my experience, I did the lectures both Sinhala and English last 10 years. Therefore, if you want to follow the Sinhala course, don't worry, you may have a Sinhala lectures also. The same lecture panel.
So I think if you have any question, you can raise our staff. Mr. Priyanta is there. He's our assistant director who is handling this training division, and Ms. Purnima, program officer, and our resource person. They are like our family members. Professor Sarveswaran, Mr. Lalit Kumara, Mr. Ranavira, and Mr. Saka. They are like our NILS family. Also, I must thank them. They always with us. Thank you, Professor Sarveswaran and Mr. Lalit Kumara, for your valuable lecture, valuable thoughts, and great help to us. Thank you, sir.
Thank you, sir.
So we will wind up the program now. On behalf of NILS and NILS, I would like to thank Professor Sarveswaran for his valuable lecture and commitment, and also Mr. Lalit Kumar Wickramarachchi, his valuable lecture, his commitment since the last 15 years. Both of you help us, and Mr. Sankar, Mr. Ranavira also joined as a participant. He is one of the key resource person of our lecture panel. He is a former Labor Commissioner, and I must thank all of you and our participants from various sectors. You have registered. When I go to your registration list, I saw that private sector, public sector, HR professional, and few are from the overseas. So thank you very much for joining with us, and hope you will join with this program on coming Sunday. Thank you, Mr. Priyanta and my team, to organize this kind of training program, awareness session. Okay, thank you very much. Good night.
Thank you, sir. Thank you so much.
Good night.
Thank you. Good night.
Okay, thank you. Good night.
Good night, sir. Thank you.
Bye, sir.